2. Welcome to the show. Can you?
Grab me a positive synergy. I have been doubted through life. Been there and done that with trifling people who told me my style will not work. I told them they wrong. They're struggling too long. This song is for you. I'm proving you wrong. Get out my way. 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 Get out my way.
What up, what up, what up, what up, y'all? What's going on? What's going on? So we got the case going on right now live. I want y'all to be able to check that out. Also, let's just see exactly what's going on with this case for Young Thug and YSL. Give me one moment here.
Justice's opinion. They all can be charged, convicted, and sentenced separately. And in fact, there is a statutory non-merger provision within the act itself. So, Your Honor, the constitutional claims fail in terms of 1615-4. So now let's look at a later enacted statute, 24-4-418. Now, this is a provision that is unique to Georgia and only applies to cases that are charged under Georgia's Street Gang Terrorism and Prevention Act. And it's patterned after, Judge, the same evidence code provisions that apply in sexual offenses and lawsuits arising from acts of sexual misconduct. Georgia has those at 24-4-413, 14, and 15. They're in the federal rules of evidence under the same numbers. And I believe, Your Honor, they're also in the military rules of evidence under the same numbers.
Hopefully y'all can hear this.
The question is, does the admission of character evidence somehow in and of itself violate the Constitution? There's been no case law provided to that effect by the opposite side. And while the
do it this way.
So we ask a question, is there a due process problem here? Well, Rule 403 applies, Your Honor, and although it is a presumptive admissibility statute that does indeed allow other acts that qualify as criminal gang activity to be admitted for any purpose, including criminal propensity, those parallel the rules that apply in sex offenses, in federal courts and in Georgia courts, and quite frankly, in other states, California, for example, Your Honor, there are similar rules that apply in elder abuse cases, special needs abuse cases, domestic violence cases, as well as in non-sexual child abuse cases. Those have been upheld, and you'll see in our brief, we've provided you with jurisdiction after jurisdiction after jurisdiction where rules that parallel this in fact, have been upheld constitutionally by federal and state courts around the country. An additional case on that, Your Honor, State versus Gee, G-E-E, that is at 388 Wisconsin 2nd, 68. 388 Wisconsin 2nd, 68, a 2019 case, and where they say, they quote, the United States Supreme Court of Dowling versus U.S. 493 U.S. 342, 493 U.S. 342 at 1990, whether the introduction of this kind of evidence is so extremely unfair that its admission violates fundamental concepts of justice. Well, Your Honor, this type of evidence, even without the gang statute involved, even without 418, is generally admissible. The rules of intrinsic evidence are relaxed, generally speaking, when it comes to racketeering cases federally. And of course, in sexual offenses, even without a 413 or a 414, those were more easily admitted under our former evidence code. And just to go to a military case on that, Judge, U.S. versus McDonald, 53 Military Justice 593, 53 Military Justice 593. Again, a direct attack there on 413 and 14 on due process grounds, and just stating that a review of the pertinent appellate decisions indicates the courts have uniformly held that such constitutional concerns are satisfied by the proper application of the Rule 403 balancing test. So is this a statute that allows other acts in presumptively? Yes. Does it allow it in for all relevant purposes? Yes. But that was the design of the statute, In fact, it's right there in the enabling language of the statute in the preamble, quote, to improve the ability to prosecute street gang terrorism and provide for the admissibility of similar transaction evidence in prosecutions for criminal street activity. And that, of course, corresponds directly with the purposes of the Street Gang Act under OCGA 1615-2 to eradicate that kind of crime. And those are the words of our General Assembly as part of and a response to a state of crisis. So the constitutional challenge to 418 fails. 418 applies. There's not a due process consideration here because, again, the statute is tailored to these considerations, and certainly criminal street gang members committing criminal street gang acts are not a protected class that would raise equal protection concerns. So now we go to this last issue of, so the constitutional challenge to 418 fails on its face. So now we get to the issue of whether or not the other acts evidence, the uncharged misconduct to be admitted under Rule 418 requires a prior conviction under 1615-4. That issue was just argued in front of the Georgia Court of Appeals successfully by Assistant District Attorney Rosenwasser in the case of State versus McKinney. I've got the Lexis site for that, 2022 Georgia Appeals Lexis 545, 2022 Appeals Lexis 545, where the Court of Appeals noted that the language of Rule 418 itself does not require a nexus in terms of the other acts evidence to be brought in between the gang, the crime, and the defendant. Only that the prior offense, the other acts, could be subsequent classified under 1615-3. So for any evidence the state is going to proffer under 24-4-418, if that offense qualifies as criminal gang activity under 1615-3, it thus becomes presumptively admissible for all relevant purposes under the plain language of 24-4-418. So, Your Honor, with regard to the facial constitutional challenges, we request that the court deny those respectfully. With of course, to the specific challenges to 1615-4 and 418 constitutionally, we ask that those be denied, and we also ask that that the court deny now and apply prospectively during the trial of this case 418 properly and reject any argument that the other acts have to have constituted a convictable offense for 1615-4. Thank you, Judge.
Okay. And Your Honor, none of that addressed any of my arguments about unfairness. It just cited to Georgia statutes and then conceded that 418 is unique to Georgia, which is why I'm challenging it so that it can be reviewed by a higher court. Because if you don't challenge anything, Your Honor, in this system of a living constitution, nothing can change. And there have been plenty of times in our history, and even recently with the Dobbs case, that there's just things have changed and courts find something to be unconstitutional. Here,
well, you made a constitutional challenge. I mean,
right, Your Honor.
So if and when this case is reviewed, our Supreme Court will consider those particular issues.
Yes, Judge. And I just real quick to perfect the record, want to address a couple of things. He said, the state said I didn't address any actual authority, but I did. In the very first paragraph of the motion, I say that this is a violation of the 5th, 6th, and 14th Amendments of the United States Constitution. It allows propensity, whereas 404B doesn't, without any rational basis. Under the 14th Amendment, for there to be any kind of discrimination, there has to be a rational basis. The basis the state articulated is to eradicate crime. But what is the rational basis that gang activity is more important to eradicate than murder, or rape, or child molestation? So why should an accused rapist not have propensity in his trial, but an accused rapist where the rape was part of gang activity that the state knew couldn't survive a directed verdict? Oh, now we got to eradicate that. That's what's not fair, Your Honor. There's no rational basis here under the 14th Amendment. It's unique to Georgia, and I don't think the state even said this hasn't been challenged. This hasn't been addressed exactly by the United States Supreme Court. And so under all that, Your Honor, I do want to challenge it and get a ruling for this court to preserve that issue for appeal.
All right, Mr. Carlson, you want to address the issue of whether or not this is or rational basis and the correct constitutional standard?
Certainly, Your Honor. This is the parallel provisions federally that apply in sex crime cases have been on the books since, I believe, 1996. There has not been one successful constitutional challenge to any of them cited by the defense. And, of course, the state has provided the court with just to the contrary. In terms of whether or not there's a rational basis here, the legislature in the preamble to the Georgia Street Gang Terrorism and Prevention Act, let me change that. In the preliminary language of it, in OCGA 1615-4, talks about the state being in a state of crisis due to criminal street gang activity, violence, to include murder. So the General Assembly looked at that situation and enacting the gang statute, and of course continued to strengthen those laws in the face of that state of crisis. Again, that's our General Assembly's terms, all the way up into drafting 24-4-418. And I would point out, Your Honor, that this is one of 4 specialty evidence code provisions that particularly applies in Street Gang Act cases. There's 1511-703, 15-11-703, which provides for the admission of juvenile adjudications in cases prosecuted under the Street Gang Act. There is 16-15-3, which is housed within the Street Gang Act, which allows in evidence of the customs and behaviors and symbols of gangs, among other matters. And then there's OCGA 16-15-9, which allows for the admission of other criminal gang activity of the gang. So there's certainly a surrounding statutory body that demonstrates the importance to our General Assembly, which is the fact finder here, that having specialized statute to facilitate the admission of street gang activity, whether by an individual defendant or whether by the gang itself, is clearly something that is necessary for public safety. Just like in the case of the sexual offense provisions, or the evidence code provisions that connect with sexual offenses, that those needs to allow in other acts at a different level than would be allowed under 404B would be. So these are legislative determinations. Again, we're not talking about a suspect class here in the constitutional sense under equal protection, and due process is satisfied because Rule 403 applies, and the Court of Appeals was absolutely clear about that in the McKinney decision. So again, we don't have a recognition of Rodriguez in terms of 1615-4 by the defense in this case. We don't have an acknowledgement of any of these cases pertaining to similar statutes from around the country or federally. And again, we have a constitutional statute that was enacted by the General Assembly to deal with the state of crisis of gang activity.
Okay.
Very, very briefly, I don't think that argument...
Don't get back to the podium. Stay right there. Very good.
Yes, Your Honor, that argument
Right.
of 403 just doesn't hold up because of the propensity difference. For example, 403, we're balancing probative...
But it's a specialized statute that the legislature enacted for purposes of this particular issue. So, I've heard your argument. Is there anything else you want to add?
Yes, I mean, just to add that under 404B, propensity is not allowed, so propensity is not probative. But under 4A...
Well, that's it. No. It's the test. After you look at whether or not 418 still requires 403 to be applied. I mean, so that's your check and balance. And the recent case that Mr. Carlson just cited in State versus Kinney, that was in the Lexus 22 Lexus 545. That's what our Court of Appeals has determined in that respect.
Well, yes, sir,
So you disagree though?
yes, we can
Okay.
disagree.
All right.
That's okay, Your Honor. What I do want to say, though, is that because propensity is allowed under 418, and going to say that as it, we're now giving probative value to propensity and allowing 403 to consider propensity as probative value, which allows us to outweigh prejudice in the way that it should.
No, it doesn't outweigh prejudice because you still have to balance it under 403.
Yes, Judge.
I mean, look, all good. The argument in a number of cases is, this is prejudicial. Well, good evidence certainly is prejudicial under a lot of times, under a lot of circumstances. However, 403 being a balancing test requires the court to not just look the other way, hold its nose, but I still have to make sure that the balancing test under 403 has been met. So, there's your safeguard.
Yes, Judge, I just think that the balance turns out differently when you consider propensity and uncertainties. But I understand that the court and I can disagree. And just last for the record, I don't think at all that being in a state of crisis is a rational basis.
Well, here's the thing with as you well learned in law school, right? There's 3 levels of constitutional scrutiny: rational basis, intermediary scrutiny, and strict scrutiny. And that for public safety, the bar's pretty low. I mean, as a general rule, and that the states or governing bodies are free to, that's the one that usually they win on most of the time, is for safety of the public. So if that's what the statute was indicated or was enacted to deal with, and if you look at the preamble when they did it, it does say we're in a state of crisis in terms of crime and other things, and that was the basis for them to enact the statute. So good luck on that. But okay, but I can't say enough that you're not representing your client, you're representing him well, and you preserved it for appeal, so you've done your job. Okay.
The very last argument I want to reserve for appeal is that the reason I don't find that to be a rational response to crisis is because there's so many other ways that's rational to respond. For example, fixing school system or defects or all those other things that you can actually address the crisis instead of strip away our due process.
Okay, well, I'm sure that you'll argue that very well to our Supreme Court, okay? If and when it's taken up, all right? Anybody else? I saw saw some other people may want to get up. Mr. Hoover or anybody else before I rule? Okay, I know all of you adopt Mr. Menezes' motion and his argument. Okay, all right. Mr. Rosenwasser, let me let you finish before I go ahead and rule. I think that you were going to talk with me a little bit about the issue of the duplicative counts as well as the constitutionality of the Georgia gang statute. Is that correct? Yes. And I think that will conclude, at least for the time being, Mr. Menezes' motions, until such time as we're able to hear those particular other witnesses, the witnesses that will require, motions that will require witnesses, I should say.
Yes, Your Honor. So first, as to the duplicative counts, if I understood Mr. Farley's written motion correctly, it was a little different than what we heard today, but I'm happy to respond to all of it. So first of all, in his written motion, it seemed as though he was complaining that counts the indictment, later in the indictment, 50 and 51, mirrored some of the acts under count 1. So to respond to that first, Your Honor, first of all, as to count 1 acts 173 and 176, those are acts under the RICO count. They are not separate counts. So what's really going to drive us both through this conversation and through the addressing of what Mr. Farley talked about today, where he alleged that murder and criminal gang activity are duplicative of one another, there's some language that guides us through that. And what I cited to in my brief is the language out of Williams versus State, which is a 2020 Georgia Supreme Court case. It's in my brief, but if the court wants a cite, it's 307 Georgia Supreme Court 778. And in that case, the court said, the United States Supreme Court observed that a draftsman of an indictment may charge crime in a variety of forms and may cast the indictment in several counts, whether the body of facts upon which the indictment is based gives rise only to one criminal offense or to more than one. Further, by an indictment of multiple counts, the prosecutor gives the necessary notice and does not do the less so because at the conclusion of the state's case, the defendant may insist that all counts are merely variants of a single offense. Here, the state was properly permitted to charge Farley's act of committing a gang murder, a gang-motivated murder, in numerous ways. The state was permitted to charge Farley with participating in the RICO conspiracy from the YSL criminal street gang, and the state was entitled to allege acts that were in furtherance of that criminal conspiracy, as alleged in count 1. In count 49, 50, and 51, the state was entitled to separately charge Farley for the act of murdering Mr. Drinks and for participation in criminal street gang activity.
Which counts those again? You said count 1?
My understanding is that Mr. Farley was challenging count 1, acts 173 and 176,
Okay.
and then also counts 49, 50, and 51. 173 and 176, count 1 acts 173 and 176 are Farley and his co-defendants' acts of murdering Mr. Drinks and participating in criminal street gang activity through that murder, and those acts are alleged as acts in furtherance of the YSL RICO conspiracy. And then additionally, Farley is separately charged in counts 49, 50, and 51 with the murder and participation in criminal street gang activity with the actual, those are the charges. So the charges that he's facing relevant to this count are that RICO charge, the murder charge, and the 2 gang charges. And the gang charges are alleged under separate code sections, separate divisions of the gang statute. So basically, these counts are not all the same, so this court should deny Farley's demur. And when I looked at this, what I believe is that this is a situation that should be analyzed similar to when a defendant complains of a double jeopardy violation. And I believe that this court should adopt that framework to analyze this challenge. The double jeopardy framework is that a single offense may be an offense against 2 statutes, and if each statute requires proof of an additional fact, which the other does not, an acquittal or conviction under either statute does not exempt the defendant from prosecution and punishment under the other. So I think to look here whether these counts are duplicative, it is whether it's similar to if we're looking at a double jeopardy or merger analysis. And here, these counts, none of these counts are the same. Count 1, count 49, count 50 or 51. Each of these counts requires the state to prove different elements. Simply because the state added language to certain counts stating that the victim, about his gang status or gang affiliation, that does not mean that the counts are duplicative. It simply is different ways of alleging the act of committing a gang-motivated murder. These counts have different charging elements, and what's important is you look at the elements of each count. So Farley is charged in count 1 with RICO. Murder is not an essential, killing someone is not necessary to prove a RICO conspiracy violation. Same thing with participation in criminal street gang activity. Committing murder, killing someone, is not necessary to prove that someone violated the Criminal Street Gang Act. They could also be convicted of that and of murder, but it's not a situation where that's going to be a duplicative count. Those are different acts. And acts is probably the wrong word due to RICO. Those are different actions taken by the defendant. They're differently charged, and that's completely appropriate pursuant to the Georgia Supreme Court, which quoted the United States Supreme Court. The United States Supreme Court case is United States versus Universal CIT Credit Corp. 344 United States 218, 1952. So here, Your Honor, the counts are not duplicative. They each require different elements. The state must prove different elements to show each conviction. Your Honor, these counts are in no way duplicative. Mr. Farley's demur should be denied.
Okay. Turn to the issue of the constitutionality of the gang statute, Georgia gang statute.
Yes, Your Honor. So turning to that directly, I think it's pretty clear that this has already been challenged in the Georgia Supreme Court within the last 15 years. That was in Rodriguez versus State, and in that case, the Supreme Court of Georgia unanimously held that the primary charging provision of Georgia's anti-gang laws, OCGA 1615-4, is constitutional. Farley has not shown why this court should not follow the ruling of Rodriguez or even attempted to distinguish Rodriguez. So therefore, Your Honor, we believe that it's already been ruled upon. This is a challenge that has already been made. This statute is constitutional. And, Your Honor, going into the challenges to each of these, to the extent that Farley makes a First Amendment challenge, Rodriguez versus State held that criminal gang activity is not protected activity even when committed by a group exercising their constitutional right to free association. So that's already been held. Again, I think Mr. Carlson went into this as well, but to the extent he didn't, or the court has further questions. Additionally, Anthony versus State Loop specifically, and that's 303 Georgia Supreme Court 399. That's a 2018 case. The Georgia Supreme Court specifically rejected the idea that all gang offenses must be gathered into a single gang activity charge. In Lupo versus State 300 Georgia Supreme Court 233, that's a 2016 case. They found that an individual can be charged with separate violations for each of the gang statutes. So that's not a reason to find it unconstitutional. And generally, Your Honor, it's just been clear that this has already been challenged and been rejected, and Farley has not shown why this court should not follow pre-established case law. And Your Honor, I do want to provide the court additionally with the Nolly site that Mr. Carlson referenced. That's 335 Georgia Court of Appeals 539 2016, and that actually goes in support of both his case and his argument and my argument.
Okay.
Y'all, we are watching the Young Thug trial live right now here in Georgia. This is live right now, so thank you all for coming in. If you're new to the channel, hit the like button, subscribe. We appreciate you being here. What's up, everybody? As y'all see, the guy who's sitting right there right now with the fro, that's the guy we talked about this morning who made that phone call to his baby mama telling her about them guns. So we was trying to ask, was he trying to hide evidence or not? So that's the guy right there that we talked about this morning on the morning show. What's up, Tias? What's up, Nanya? Rocco with the truth, what up? Just T, what up? Cherie Harris, hello. Nanya, hello. Thank y'all for coming over. Kanza, Latrice B, Cherie Harris, I'm a Queen, Riri, April Showers. Latrice B, thank y'all for coming over. I appreciate it. Yeah, I don't know if he knew that they recorded or not, Kanza, but it says it right on the call that they record every single phone call, and it can be used against you in court. They record all calls, right? This dude was on there talking about, hey, I got a gun over here. Should I sell that gun? Should I move this gun? And it was, it's crazy. And they use it against him in court. What up, Ty? This is raw as it get, y'all, right here. This is raw as it get as far as knowing exactly what's happening in that courtroom, who's saying what, who said what. Right back. You. Hello. Hello. I think the judge is about to. Yeah. Like I said, these guys got to know that these phone calls they making to their baby mamas or whoever are recorded. This is the dude right here who we talked about on the morning show this morning. Matter of fact, his name, I got it right here. So that's Farley. So Farley, that's the guy we're looking at right there in the middle with his head down. Farley. That's the guy who made the phone call this morning. He said they said I shot and killed somebody, and then they say gang charges, and he cussed and initiated to get rank. And he said out his mouth, y'all, like I'm trying to do this shit for rank. So like, what else can you say? It's like me saying, like I shot her because I wanted some publicity. It don't make no sense. Hey, Lady D, how you doing? Long time no see. Well, we'll see if he get this murder. He the one that got the murder charge. He has a murder charge, so we'll see what's going on. Obviously, he's affiliated with Young Thug and YSL. It's going to be interesting to see if they try to hold against him that phone call. It's going to definitely be interesting. This judge seems pretty laid back. He seems pretty cool, right? He don't seem like he let them. I know he had an arguing match with the prosecutor, the prosecution the other day. The day that Young Thug won his motion to suppress evidence. Yeah, Kanza, playing a cold game. It's a cold game out here. I believe that's the judge, y'all. They say it's got a pit bull, a dog up there with him. Somebody said he came in there with a dog on the chain up there with him because of the high security. Here we go.
Okay, counsel, I appreciate you all giving me some time to collect my thoughts on this particular issues. As it pertains to Farley's motion in regards to amended and special demur 7 duplicative counts, this court has considered that Farley is charged in count 1 acts 173 and 176, and counts 49, 50, and 51. And applying, as is mentioned, Williams 307, Georgia 778, these counts are not all the same, where they require different elements of proof, and Farley's motion on that particular issue is denied. As it pertains to the constitutionality of the gang statute, which is 16-15-4, this court has considered the counsel's arguments, in particular Rodriguez versus the state, which is a seminal case dealing with the constitutionality of this particular statute at 284 Georgia 803. The proponent, Mr. Farley, has not shown how Rodriguez is not constitutional. It's not. This particular statute deals with doesn't protect activity as authorized by the First Amendment in terms of freedom of association. So it's not a protected activity. So criminality and the prosecution thereof of that is different than the issues under the First Amendment in terms of freedom of association as authorized or guaranteed to us by the First Amendment. So Farley's motion on that issue fails as well. In terms of the motion to declare 24-4 4-418 admissibility of gang activity. I agree with Mr. Carlson. The facial challenge fails under Brennan 267 Georgia 315, and the First Amendment challenge under Rodriguez fails. Our Georgia Supreme Court is dealt with that issue according to the case is cited. Mr. Farley also challenged a number of issues involving 16-15-4, which prosecutes conduct, not associations, the court just mentioned earlier. 16-15-4B addresses behavior. 16-15-4M, in terms of the double jeopardy argument, there is no merger. I agree with Mr. Carlson for the and Ms. Rosenwasser for the propositions as stated in Nally versus the state at 335 Georgia Appeals 539, Lupo versus the state 300 Georgia at 233, and Anthony versus the state at 303 Georgia 399. In terms of the constitutional challenge of 418, the issue of uncharged misconduct, there is a built-in mechanism, as I talked with Mr. Farley's counsel, Mr. Menendez, about the issue of it requires the application of the 403 balancing test, and that also is found and is written by our appellate court in State versus McKinney. The Lexus site 202 Lexus 545 has been provided by Ms. Rosenwasser already. So the court is of the opinion and agrees that the issue is not nexus in his classification. So Farley's motion in those regards fails. And in terms of finally his constitutional classification of 418, the preamble, as our legislature has indicated before enacting 418, and that's 24-4-418, is the reason was that our state was in a state of crisis in terms of criminality. So 16-15-4 and 24-4-418, as I mentioned earlier, Mr. Menendez said, we certainly have 3 levels of constitutional review and review to challenge the constitutionality of statutes: highest strict scrutiny, intermediate scrutiny, and then rational basis. And since our legislature has indicated that the purpose of the statute is one of the specialized statutes in terms of public safety, public safety is a relatively low bar for a governing body to meet. And most statutes that are enacted for that particular purpose are found to meet that standard. And for those reasons, the court is going to deny your motion in terms of constitutional classification. So that, I think I've ruled on everything at this point in time. Mr. Carlson and Ms. Rosenwasser, if you would prepare a suitable order as quickly as possible to permit us to go ahead and let us enter that in the record, that would be greatly appreciative. Okay, all right. Mr. Johnson, you stood up for something?
Yes, Your Honor, as you were aware, we had joined in on Mr. Menendez's motion with regards to different counts in the indictment. I did not hear anything from the state as it relates to that. I know that the court has issued a ruling as it relates to the counts that Mr. Menendez brought up, but I did not hear anything as it relates to the matter that I brought up.
Which counts are you talking about for your? For, oh, you want to address that?
Right, Sheree Harris.
No,
I feel
sir.
the same way. That's crazy. So pretty much all Farley's motions got denied, y'all.
I mean, I can put it in progress right now. I haven't got it. This was not written, so I don't have a written response to the board. Regarding to the extent he's challenged, I think this is Mr. Eppinger, is challenging only 34 and 35. Governor, I could just have a few moments for you.
I tell you what, I'm going to reset. Did you file a written motion, sir?
Not on that. I joined in.
Say again?
No, Your Honor, I joined in Mr. Menendez.
But it's new count, so I didn't know if you were.
Yeah, it's not the same. It's not the same issue because that count doesn't apply to you. It only applies to him. So you probably need to go ahead and reduce it to writing. But I'll go ahead and let her go ahead and do that. No, I won't take it up now, but, because I'd like to go ahead and rule on. There are a lot of things I still have yet to rule on, so the way I can treat it. Ma'am, I'll give you about 10 minutes, and then we can go ahead and finish that up, if you don't mind. I need to... All right, we're going to go ahead and do that. Council's... Since I can't talk with all of you, can you all send a representative up here to the bench, please? And then the rest of you can pick one or two of you, and then I can go ahead and I'll talk with you. Is it?
I guess they doing a... Is this a sidebar, I guess? I guess this is a sidebar that they're having right now. Yeah, it's not looking too good for Mr. Farley, that's for sure. I guess they're having a sidebar, y'all, because it's like completely quiet. So what y'all thinking about this case? Do y'all think that all these people have, let's say, gotten plea deals because all of them snitched universally? Do you think they all are throwing Young Thug under the bus? If you think all the ones who got plea deals are throwing Young Thug under the bus, put a 1 in the chat. If you think everybody who got a plea deal is throwing Young Thug under the bus, I want to get a 1 in the chat for yes. If you don't think so, put a 2 in the chat for no. Please. So right there having Riri said, heck yeah, okay. Conja said, yeah, they throwing him under the bus, okay. Ty said, yeah. Dead World said, no, I think it's part of the plan. Okay, Died Joe World said he think it's part of the plan. Okay. Which plan are you talking about, Died Joe World? What plan are you talking about? Just a T Please says, okay. Conja, Riri said it's all part of the plan. Okay. It's interesting. Cherie Harris says somebody going to stay in jail. Okay.
For purposes of perfecting the record, and
Yes.
Mr. Williams, we would take exception to the court's rule in that regard. Our argument essentially would be that the same arguments in regards to Daubert and 702 that we proffered previously would apply to whether he's being qualified as a forensic analyst or a video enhancer. And we believe that these statements and the evidence that's been put forth so far do not meet the requirements of Daubert or 702, even under this newly proffered expertise.
Well, I'll of course professionally disagree with you. I think that from the court's listening to his testimony, Mr. Panay's testimony, he's been doing this for 30 years. There is a methodology that he follows, the 4-part division. That certainly he followed that in this particular case. I think that would be helpful to the jury in this particular matter. So it's different.
Let's see if they've resumed. Okay. So it looks like they've resumed. All right, so let me see what this is here. That was an hour ago. Okay. So it looks like they've cut it off for today, y'all. Okay. So it looks like they resumed. I checked into it, they didn't cut it off, so that's what that is. But y'all, man, leave your comments in the chat what y'all think is about to happen. All right, so as this thing comes back, I will continue to report on it. An hour ago. Okay. So it looks like they've cut it off for today, y'all. Okay. I want y'all to have a blessed day. We cover this thing. We've been covering it a lot lately, so I felt like it only made sense for me to come on here and talk about exactly what we see going on. And so that's why we're here, okay? But listen, y'all have a blessed day, and I will holler at y'all later. Hold on, let me see. Herbert Moffitt says, my opinion is some hidden agenda-ish, similar to what was going on with Dirk and King Von. Okay. Riri said they want more than just one person. They want as many wins of gangs off the streets as possible. Indeed, that makes sense. All right, y'all, listen, I'll holler at y'all later on. We'll see how they come on tomorrow or if they come back. Y'all have a blessed day. Peace out.
1, 2. Welcome to the show. Can you?
Grab me a positive synergy. I have been doubted through life. Been there and done that with trifling people who told me my style will not work. I told them they wrong. They're struggling too long. This song is for you. I'm proving you wrong. Get out my way. 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 Get out my way.